Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. First, Barry Morphew. Yep, that's right. Got another win. Second, Prince Andrew goes on the offensive. Third, the judge wants more discretion in the federal plea regarding the McMichaels. An example of crime happening anywhere to literally anyone. We've got the video to prove it. And then our dumb criminal of the day. Let's talk about it. Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. It is Tuesday, February 1st, 2022. All right, it is Tuesday. What is the significance of a Tuesday? The significance of Tuesday is that it is our Tuesday night show after dark. And tonight we have a guest. We have a cold case detective from the Weld County Sheriff's Department coming in to talk to us about cold cases, what he does, the cases he solved, and the cases that he's working on. I think you're going to enjoy it. And we'll talk about whatever else comes up. All right, you know the drill. If you haven't done so already, please hit that subscribe button, hit that little bell so you receive notifications of when we go live or put up new content. And always remember and never forget, that's right, if you can't watch us, you can always listen to us by downloading Crime Talk with Scott Reich on any of your favorite podcasting apps. Let's get to the news. All right, Judge Ramsey Lama, he's the new judge in the Barry Morphew trial. Well, guess what? He is moving Barry Morphew's trial into Fremont County on the grounds that Morphew could not receive a fair trial in Chaffee County, according to the court order. Now, as we all know, most people should know, Morphew is charged with the first-degree murder in the death of his wife, Suzanne Morphew, who disappeared from the family home or their close surroundings there in the county on May of 2020, specifically on Mother's Day. Now, the trial is set for May 3rd and will now take place in Canyon City instead of Salida. For your reference, Canyon City is about 60 miles east of Salida, and this is obviously a high-profile case, and it's a relatively small county with a small jury pool, which the court noted in its order. The media saturation is high. The pretrial publicity in this case has been massive and pervasive, and the prejudice that the defendant will not receive a fair trial is high. Let's just go straight to the order. All right. Now, the applicable law, the Sixth Amendment, ladies and gentlemen, the Sixth Amendment to the United States Constitution guarantees everyone accused of a crime, a criminal defendant, the right to a speedy and public trial by an impartial jury. That's right. And that has to be within the state and the district wherein the crime shall have been committed. And the court notes that the defense filed the appropriate motions, the prosecution filed their response, and there was a reply brief. The court went through the law, as they should in all good legal writing, and it says the factors to be considered by the court when determining whether there is such a massive, pervasive, and prejudicial pretrial publicity to bias a community include: 1, the size and type of the locale, the reputation of the victim, the revealed sources of the news story, the specificity of the account of certain facts, the volume and intensity of the coverage, the extent of comment by the news reports of the facts of the case, the manner of the presentation, and the proximity of the time of trial, and the publication of highly incriminating facts not admissible at trial. Remember that because that's going to be significant. First, the court goes through its analysis, the size of the locale. He goes through the fact that Chaffee or Chaffee County, depending on what part of the state you live in, has 16,535 residents over the age of 18, living in 8,231 households. It's the type of community where people know each other. There are approximately 10,000 residents who live outside the cities and towns, with several thousand more part-timers who return to their homes during the spring and summer. The reputation of the victim. The court notes that Suzanne Morphew, once she was reported missing, the disappearance of Suzanne Morphew immediately garnered widespread community interest and media coverage. And according to Abby Jefferson, who's one of the people that filled out the affidavit that's required for a change of venue, many members of the community were highly suspicious of Mr. Morphew and his involvement in his wife's disappearance. And the defendant's exhibit demonstrate the media's portrayal of Suzanne Morphew and her reputation in the motions. And even more so, the court notes the defendant points to the annual memorial Christmas tree in Riverside Park in downtown Salida is there in honor of Suzanne Morphew. The revealed sources of the news stories. The majority of the sources covering the Morphew trial, as demonstrated in the record exhibits provided by the court and local Chaffee County media outlets, is the local news channel. And they specifically reference the Fox 21 affiliate down there and Laura Schraff. And they also note that the local newspaper has received widespread publicity. The court also noted the specificity of the accounts of certain facts. Here they cite the news coverage related to the preliminary hearing and the proof evident presumption great. The volume and intensity of the coverage. This is what I think was the deciding factor for the court. Although the court goes through the analysis, I think this is significant. And the first thing he does is he blasts the district attorney. One, for making extrajudicial statements, knowing that there was a protective order, a gag order basically on the district attorney from making any statements. And when Barry Morphew is arrested, goes and comments on his silence, knowing that that would never be admissible in court whatsoever, but it was done only to prejudice the potential jury pool. And then she goes on profiling evil, and the court notes even the name is prejudicial. And so the district attorney to go on that podcast and materially prejudice the potential jury pool is basically unacceptable. Additionally, the extent of the comment by the news reports on this facts alone, the court says, listen, I'm taking basically judicial notice of the fact of the motions hearings that I've been involved in, and this is so pervasive that he's one of the factors why Mr. Morphew cannot receive a fair trial. He also notes that the trial is currently scheduled to begin in May, just over 3 months from now. And he says the publicity is ongoing and doesn't seem at this time to have to end to any of the publicity in sight. But this, I think, is the second biggest factor. One, the publication of highly incriminating facts not admissible at trial. So I've been taking a beating by several people saying, Scott, you don't know what you're talking about. You just want Barry Morphew to walk free. No. Listen, we give Barry Morphew the presumption of innocence. I don't know what, if anything, he did to his wife, okay? The court has said there's probable cause for a case to go forward. Now, whether the prosecution can prove that case beyond a reasonable doubt, we will wait and see at trial. But here's what the court notes, and this is what I've noted as well. The court has concerns about the information contained in the 130-page affidavit, something I had never seen in my 27 years. And the court notes that in his 30 years, he's never seen an affidavit like this. And a significant portion of the information in the affidavit was not relevant to the court's finding of probable cause and possibly not admissible at trial. Huge, ladies and gentlemen, huge. The court notes the presence of nearly 100 footnotes in the affidavit, which provides commentary from law enforcement on the veracity, the truthfulness of defendant's statements, along with statements about having declined a polygraph test and numerous photographs of him while being interviewed by law enforcement. The affidavit also contains statements from witnesses about Suzanne Morphew being a nice and a good person, and other statements expressing negative opinions about Mr. Morphew, both with regard to his alleged involvement in the disappearance of his wife and possibly murdering her. The affidavit also, as the court notes, includes numerous details from multiple sources of the Morphew's marital issues, their sexual history, and Suzanne Morphew's participation in an extramarital affair. This is not an exhaustive list of the type of information in the affidavit for which the court has concerns. Release of this information prior to input and redaction from the parties and prior to the defense beginning their investigation could hamper Mr. Morphew's ability to effectively prepare for this case. That is huge, ladies and gentlemen. I have said this, and you can criticize me. Like I said, I don't care if Mr. Morphew did or didn't do it. We're looking at this case, trying to look at it objectively. I have said the DA's case appears weak based upon my experience. Now we have the judge saying, District Attorney, you're screwing this case up. Now, he didn't say what would Scott say, but basically he said what Scott has said. The DA is screwing this case up. And oh, by the way, the police screwed this case up. And the court has commented now that the police should be held responsible. Basically, you have a change of venue problem? district attorney, citizens of Chaffee County, guess what? Blame the police in their unprofessional preparation of that affidavit for an arrest warrant. More specifically, the district attorney going on talking about a high-profile case, knowing that there's a gag order in place. I just don't know what to say. And I hate to say, I told you so, but it's nice when people say, hey, Scott is correct. Not for my own ego, just for the people, the haters out there that say, oh, Scott, you just want Barry Morphew to walk free. I really don't care what happens to Barry Morphew. We're just trying to look at this and say, hey, is this man going to get a fair trial? Does the prosecution have enough evidence to prove this case beyond a reasonable doubt? So then you may say, okay, Scott, what is the significance of moving it to Fremont County? Well, the significance of that is that it is in the same judicial district. Under the rules regarding change of venue, the judge can move a case basically on motion or on their own motion to a jurisdiction within their same judicial district. The 11th judicial district includes Park County, Chaffee County, Fremont County, as well as Custer County. Now, hopefully Frank can put up a nice, better picture than what I'm holding up here. But as you can see, this is the area where it is. So the court had several options in which to go to. Now, why the significance of Canyon City? The defense may be careful what you wish for. The majority, I don't want to say the majority, a large population in Canyon City are people that work for the Department of Corrections and the Federal Bureau of Prisons, because that's where many prisons are here in the state of Colorado, as well as the federal prisons are down in Canyon City. So the residents usually work for the Bureau of Prisons. There's other people that work down there. There's beautiful things down in Canyon City. The Royal Gorge is down there. So not everybody works for the prisons, but that is a predominant group of people down there that work for the Department of Corrections. So we'll have to see if it plays out in the end. Bottom line is the prosecution is still screwing up this case. And instead of me just saying it, now you've got the court saying it as well. Maybe they need to figure out what they're doing wrong. Next on the docket, Prince Andrew goes on the offensive. Prince Andrew's lawyers want to interrogate Virginia Roberts' husband over her alleged role in recruiting and trafficking underage girls for, that's right, that guy named Jeff. As we know, Miss Roberts is suing Prince Andrew in New York for battery and intentional infliction of emotional distress after claiming in a civil suit that she was trafficked by that guy named Jeff and forced to do things that she didn't want to do with Prince Andrew on at least 3 occasions when she was 17 years of age. Now, the Judge Lewis Kaplan, has now written to Australia's Attorney General to help arrange an interview with Miss Roberts' husband after the Andrews legal team invoked the Hague Convention to question him under oath in pleadings on Monday. Now, in his letter, the judge said Prince Andrew's lawyers want to speak to Robert Jeffrey, who's now married to Miss Roberts, regarding the couple's living arrangements in Australia, conversations he's had with his wife about Prince Andrew, her alleged childhood abuse, and the aspect of her income. The judge also asked that the Australian Attorney General help to obtain an interview with Virginia Roberts' therapist, a doctor by the name of Judith Lightfoot. Now, Prince Andrew's lawyers say they want to get their hands on Virginia Roberts' medical treatment records detailing any diagnosis she may have been given, as well as her medical history. They also want to access the bills charged by Dr. Lightfoot, as well as any alleged emotional and psychological harm and damages suffered by Miss Roberts. These interviews are expected to take place sometime in late April. Now, you may say, Scott, why would anybody be allowed to get to that information? Isn't there such a thing called a rape shield law? Well, some states don't necessarily have a rape shield law when it comes to civil matters. And remember, that is a civil matter. And more importantly, when you claim damages, you get to explore and find out truly what the extent of her damages are. And if she's had a bunch of other childhood trauma or other issues, it reduces the amount of alleged damages that she can claim in the civil suit. When you go sue people, you open up your history to just about everything. So we'll see how that goes. I'm sure it's going to get nasty. And people have to remember, when it gets to litigation, usually negotiations have somewhat broken down. And at that point, the other people want to, well, ruin the other people. And so it is game on and things are going to get nasty. And remember, when you hire your lawyer, oftentimes what you hire them for is the games that they can play. That's right. Sometimes you can say to your client, do you want to play games? Or you tell sometimes you can tell the district attorney, fine, you want to play games? I got more games than Milton freaking Bradley. Let's go. So we'll see how things go for the prince. Next on the docket, the Ahmaud Arbery matter. As we brought you the story yesterday, the McMichaels were to enter a plea which would allow them to serve their sentence based upon a plea to violation of Ahmaud Arbery's civil rights in federal court. The family of Ahmaud Arbery was very upset with that, and they wanted the judge to reject the plea. Now, the judge would not go forward with the plea yesterday, but it wasn't because of necessarily the request of Mr. Arbery's family. What it really comes down to is the fact that the judge wasn't going to take a stipulated sentence. And I can tell you, in all my years in federal court, I don't think I've ever had a stipulated sentence in federal court. And a stipulated sentence is where the prosecutor and the defense say, hey, judge, we've reached an agreement and you're going to do this. We've stipulated that. And the judge usually goes along with it. In federal court, judges don't like to be seen as or looked upon as basically puppets. They don't like to be told what to do. They are United States District Court judges. There's a joke out there that goes basically like this. Do you know what the difference is between God and a United States District Court judge? Well, God doesn't think that he's a United States District Court judge. Bottom line, they get to do it the way they want to. This judge wants the discretion to impose a greater sentence. The judge didn't appear to be too concerned about the fact that the sentence would be served in federal custody, which is a general perception that it is in fact more comfortable. It may be a little more comfortable, but as of today, all 152 federal Bureau of Prison facilities are on lockdown as a result of a basically gang fight down in Texas, and they believe that it could roll over to a bunch of other places. So like I said the other day, prison is prison. It is a dangerous, dangerous place. We'll see if the parties can come to an agreement, or if not, we're going to have a federal trial real soon for the McMichaels starting next week. Please go to CrimeTalkSearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to CrimeTalkSearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to CrimeTalkSearch.com, sign up today. You'll be happy you did. All right, next on the docket. If anyone thinks that crime cannot happen to anyone just about anywhere, take a look at this security video taken in a neighborhood in New Orleans. It shows two suspects attempting to kidnap a 34-year-old woman as she was walking down the street at 11 p.m. Now, thankfully, the woman was able to get away, but the police say the suspects fled when they saw another car coming toward them. And no arrests have been made. Now, you can see in the video, see a black sedan pull over on the street, and the passenger side front seat and back seat door opens. A man steps out of the car from the back seat passenger side and grabs the woman, and both men try to fit her in the car. Now, anyone with information should contact the detectives in the New Orleans Police Department, 5th District, at 504-658-6050. Ladies and gentlemen, be aware of your surroundings. Be aware of your surroundings. It can happen to anyone, anywhere. We brought you too many videos of situations like that taking place. Be careful. And next on the docket, police in Fort Pierce, Florida, responded to a domestic disturbance call and spoke with a woman who said she had been struck by a hot ramen noodles. The woman said Brandon Smith threw the noodles at her and hit her with the hot pot after they had a fight over allowing Smith's dog onto the bed. When Smith was questioned, he said he woke up and began making ramen noodles. Then he said the victim was running around chasing the dog when she fell into the ramen noodles on the stove. Smith was arrested for domestic battery and booked into the St. Lucia County Jail, where he's being held in lieu of a $5,000 bond on a misdemeanor count. Ladies and gentlemen, more food. I don't know what it is. If you're going to have an argument, don't make food. Don't be around food. Don't be around sharp objects. Maybe just have a conversation saying, I don't think that you're respecting me by having the dog on the bed. Maybe something along those lines. Or what problems could we solve by not having the dog on the bed? Those types of things. So, Mr. Smith, unfortunately, you made the dumb criminal contestant of the day. Well, for even having the argument over the dog. Go sleep on the couch and eat your noodles on the couch. All right? All right, thanks for watching. Please join us tonight at 6 p.m. Mountain Time for our live show After Dark, where we have a cold case detective here to talk to you about cases he's working on and the cases that he's solved. We'll see you later. We'll see you next time on Crime Talk.